Okay, so let's begin now with the technique of the QME examination. And we're now approaching the time where we meet face to face with our injured worker. We have firmly in place a good attitude. We are in a liberal construction frame of mind. It might be early, 9 a.m., say on a Wednesday morning, and you're getting ready to meet the examinee for the first time. So I want you to remember that the QME examination begins the moment you see the injured worker in the waiting room. And it's at this moment in time, when you first meet each other, that every detail counts. Now, as you approach the injured worker and you sharpen your senses and start observing him, I want you to be aware of the fact that the injured worker and whatever family members he may have with him, they are observing you as well. So Webster's dictionary defines the word observe as meaning consists of receiving knowledge of the outside world through the senses. And just as you are watching and listening to and receiving information about the examinee through your senses, so is the examinee receiving and watching and listening to you through his senses. And so every detail counts, and this is a critical first moments. And I want to share with you a couple of ideas about procedures, the purpose of which are to establish a friendly rapport and to allow the examinee to relax and to allow the examinee to drop his shoulders and to allow the examinee to become comfortable with you. So this begins by greeting the examinee in the waiting room. You establish communication with the examinee with a handshake and a genuine and sincere smile. A genuine handshake and a genuine sincere smile. These are critical first moments, and you've heard it said that you never get a second chance to make a strong first impression, and you want your strong first impression to be of caringness, of kindness, and of an attitude of liberal construction. Meanwhile, you gather information about the posture and the activity level of the examinee. You gather information as to the examinee's station and gait, whether or not the examinee presents with any appliances, with any assistive devices, with any supports. And you begin the qualified medical evaluation early in the examination and the waiting room. Now, if the examinee is attended, it's important that you assess the relationship with the person that's accompanying them. Many times this will be a family member, it could be a spouse, it could be a child, an adult child, but assess the relationship with the person who is accompanying them to the evaluation. And establish rapport with this person. Introduce yourself to this person. Get their name and call them by name. Let them know that it's a pleasure to meet them. And it's at this point in time that I like to advise the attendant of what they can expect over the next couple of hours. I let them know what's going to happen. I let them know how long it's going to be. And then I ask them what they would like to do during this time. Do they want to remain in the waiting room? Do they want to relieve the waiting room and leave the office, perhaps to do some shopping or do some errands? And the script to this discussion may go as follows. So you approach the examinee in the waiting room, you reach your hand out, you give them a nice smile, and you say, "Hi, Mr. Jones. I'm Dr. Carpenter. It's nice to meet you." And he will respond. Then you turn to the person who's attending them and you say, "Hi, are you Mrs. Jones?" And she may say, "Yes, I'm Mrs. Jones." Or she may say, "No, I'm the daughter Becky." In any event, you shake this person's hand and you say, "Hi, I'm Dr. Carpenter. It's nice to meet you. And then you advise them of what's going to happen. You say, we're about ready to begin. I expect that we're going to be somewhere between 2 and 4 hours. Don't exactly know how long we'll be, but it's going to be somewhere between 2 and 4 hours. It just depends on what becomes necessary back there. Now, Mrs. Jones, do you have a cell phone with you? Yes. Okay, well, you have a couple of options. You can either wait here in the office, or if you want, you can go and do some errands or whatever you need to do. And as we come close to the end of the evaluation, we'll give you a 30-minute heads up by cell phone. Would that be okay? And they'll generally look at each other, the husband and the wife, or the examinee and the child, and they'll decide amongst themselves which of those sounds like the better option. Many times they'll simply leave the office and go and do some errands, and under which circumstance you can call them 30 to 45 minutes in advance and let them know that you're rounding third, heading for home, and you'll be done shortly, that they can come and pick up their family member. Or in some rare circumstances, they will wait around in the waiting room with nothing else to do and simply wait for the evaluation to complete. I prefer to have the attendant leave the office because that tends to relieve the waiting room and tends to make things easier on the office. But either option is appropriate and either option is okay. Okay, so then the examinee gets up with you as you proceed back to the examination room. Now, on the way back to the examination room, you're going to want to gather some critical data. You want to observe the gait of the examinee to the examination area. Now, the gait evaluation begins by watching the examinee rise from the waiting room chair. You'll recall that one of the gait disturbances involves difficulty rising from deep chairs. This is what we know as the positive minor's sign. So you're going to be observing for how the examinee rises from the waiting room chair and how they ambulate back to the examination room. And what I like to do is I like to walk backwards in front of the examinee. I walk backwards down the hallway towards the examination room, and that way I can observe them as they ambulate down the hallway as well. And as they get to the end of the hallway, I'll simply ask them, how are you walking? Are you walking okay? Do you have any kind of a limp? Do you have any kind of a gait disturbance? How are you walking? Are you walking okay? And they will tell you. Now, if there's no noticeable disturbance of gait, no limp, no difficulty, then you make a mental note of this, that pretty much the gait evaluation is not going to be necessary. For any type of gait issue, you want to make the opposite mental note to perform a formal gait analysis later on when it comes time to do the physical examination. When you arrive back to the examination room, it's important that the examination room look to be in perfect order. Perfect order. You want all materials set out in an organized and a visible fashion. You want the chart to be available and organized. You want all your testing instruments laid out in order and in sequential order with the examination. And I want you to think in advance, how the room appears to the injured worker. And to illustrate this point, I want you to think about the last time you went to a restaurant. Imagine you're being escorted to your table. You like your table to be ready for you, ready to service you, ready to be a pleasant place for you to spend the next 30 to 60 minutes dining. You want your napkins in place. You want your silverware all lined up and organized. You don't want to see smudges, ketchup stains, gum wrappers and stuff on your dining table, on your table. You want everything in order. How about the last time you went to a hotel room? Imagine that feeling that feeling of suspense when you open the door to your hotel room for the first time. You slide the key in the door, you turn the doorknob, and you open the door. Isn't there always a period of suspense where you wonder, what kind of room am I going to get? Am I going to be overjoyed with this room? Am I going to be pleased with this room? Or am I going to be disappointed with this rundown, messy, decrepit looking room? Well, similarly with the qualified medical evaluation, the examinee comes to the evaluation to receive some service from you. They come to the evaluation to receive some benefit by their relationship with you, even for the short duration of the evaluation. I want the room to be in perfect working order, neat and tidy. It doesn't mean that everything has to be brand new, but what it means is that everything is neat and tidy and clean and organized and ready and in position to service the examinee. Okay? So everything tidy, nothing out of place, everything perfect from the eyes of the examinee. Once the examinee and you arrive back to the examination room, I want you to take extra effort to get the examinee comfortable by taking their coat, by providing them a place for their things, by getting them comfortable in their chair, by letting them settle in. And I'm asking you to be sort of like a butler. I'm asking you to be service-oriented to the examinee. Now, I'm not asking you to be subservient, but I'm asking you to be sort of service-oriented. And this goes a long way toward establishing the tone of a comfortable environment, a service-oriented environment, and an environment wherein the examinee is comfortable. And that's really what you hope to accomplish, is that the atmosphere is an atmosphere where you too can comfortably communicate over the course of the next 1, 2, 3, or 4 hours without any feeling of apprehension or tension between you. And I have a few other suggestions for you in terms of creating an atmosphere and a comfortable tone in the evaluation. And let me give you a couple of ideas along those lines. I want you to think first of all about the perspective of the examinee coming to this evaluation. You know, in the workers' compensation system, as far as the examinees and injured workers are concerned, it's a stressful environment for them. Many times they feel like they're jacked around. Many times they feel like they've been treated unfairly. Many times they feel like they don't know the system, and so they can't possibly fairly compete within the system. And it's a stressful situation for them. Many times they're not getting their benefits on time. Their treatments are interrupted or denied or delayed, and so it's very stressful sometimes for examinees. Well, our job as qualified medical evaluators is to make them comfortable, to make them relax, and to provide some benefit to them as a result of their relationship with us, even as brief as it may be. So we can help establish a comfortable environment and a relaxed environment and a service-oriented environment by our communication style with the examinee. And I want to give you some ideas to help establish a comfortable atmosphere within the examination room. And this falls under the topic heading of establishing the tone of the qualified medical evaluation. You want to establish the tone of the evaluation by using caring words, by using kind words. You want to be sort of official. In other words, this is an official proceeding. It's governed by many labor codes. It's governed by many codes of regulation, and it is an official proceeding. However, that does not negate or obviate the fact that you can carry on and carry yourself in such a way that conveys an attitude of caringness and an attitude of kindness. And it's my experience that using caring tone and using kind words helps establish the doctor control of the proceedings. And that's one thing that we never want to relinquish is our control over the proceedings. So let me give you a couple of quotes from some notable authors and personalities. And you may have heard of some of these in the past, but I want to illustrate the point of using caring and kind words and the power of caring and kind words in establishing an appropriate tone that helps accomplish our objective of creating a comfortable atmosphere. So Albert Schweitzer said, and I'm just going to give you a couple of quotes here. Albert Schweitzer said that constant kindness can accomplish much. As the sun makes ice melt, kindness causes misunderstanding, mistrust, and hostility to evaporate. And isn't that exactly our objective with the qualified medical evaluation? To cause misunderstandings, to cause mistrusts, to cause hostilities to evaporate. That's exactly what we're trying to accomplish. And we accomplish that by using constant kindness, constantly being kind to our examinee. Blaise Pascal said, kind words do not cost much, yet they accomplish much. And we can accomplish a lot in our qualified medical evaluation simply by the use of kind words. Thoreau said, the only way to tell the truth is to speak with kindness. Only the words of a loving man can be heard. And isn't that what we want? Don't we want to get to the truth? We want to discover the truth of our examinee's true condition, not their understated condition, not their magnified condition. We want to get to their true condition. And the way we get to the truth is to speak with kindness. When we speak with kindness, we create an atmosphere that's comfortable for our examinee and creates an atmosphere where the examinee is comfortable and communicating with us, to us, with openness, with honesty, and with truth. And finally, Mark Twain said, kindness is the language which the deaf can hear and the blind can see. And this kindness begins all the way out in the waiting room with the examinee and his attendant, whether it be the wife or the child. And it carries through all the way through your introductory remarks, all the way through your interview process, and all the way through the examination procedures. Kindness, caringness, and loving words, and really an attitude of liberal construction. This makes it more likely that the examinee is going to be honest with you and therefore make it easier for you to come up with conclusions that are accurate and that are a true representation of the examinee's current condition. With that as our philosophy, we then begin some of the administrative procedures involved with initiating our evaluation. And some of those steps include collecting the paperwork that you may have sent to the examinee prior to the appointment. You want to make sure that you review this paperwork for full completion and for signatures and dates wherever those are called for. If any paperwork is not completely filled out, make sure to go ahead and take this time to have the examinee fully complete all necessary paperwork. Then exchange driver's licenses with the examinee. In other words, hand the examinee your driver's license and ask them, do they have photo ID as well? And I'll talk to you a little bit about some of the reasons for doing this in just a moment. When you obtain the examinee's driver's license, you want to take a look at it and confirm their height and weight, number one, with their height and weight as they present in front of you today. You want to compare the address on the driver's license with what you have in your demographic profile of the examinee. And also document the examinee's driver's license in the demographics section of your QME report. Also, you want to provide the examinee with a copy of your QME certificate, and this, by the way, is a required procedure. Now, these procedures of exchanging the driver's license and providing the examinee with your QME certificate help establish the doctor control and the sort of official nature and official tone of the evaluation. And what would be some other reasons for obtaining the examinee's driver's license? Well, how about number one, to confirm that they actually do have a driver's license. Many of the examinees drive themselves to the appointments, and having a driver's license gives you a lot of information as to, well, let's just say it gives you a lot of information. It especially gives you information if they do not have a driver's license. What's another good reason to obtain a driver's license? Well, it allows you to identify the examinee and confirm that the examinee in front of you is the same as the person who you're supposed to be evaluating. It also gives you very valuable demographic data and allows you to document any change in their conditions, such as their height or weight, over a period of time. Okay, and also helps establish sort of an official tone wherein you identify yourself in open disclosure to the examinee by showing them your driver's license and then also showing them your QME certificate that is valid and effective for the location at which the evaluation is being held. Okay, so once these official procedures are out of the way, you're then in a position and then ready to begin your face-to-face evaluation, which begins with a few strategic opening procedures and opening remarks. So let's go over the opening remarks right now. So the purpose of these opening remarks and opening procedures is twofold. Basically, is number one, to get the examinee comfortable with you and comfortable with the environment, and then number two, for you as the doctor to establish a tone of control over the proceedings. And there's one more procedure before we begin the actual face-to-face interview with the examinee. And before we finally discuss that, I just want to reiterate that the entire process of establishing rapport with the injured worker and going through these procedures in a painstaking fashion is to make sure that the examinee is comfortable. As we said, many times this is a stressful procedure for examinees. So it's important that the examinee be comfortable, be physically and emotionally comfortable, and that they feel like they are in a safe environment with you as their evaluator, and that they've made a correct choice in selecting you or having you as their evaluator. So take extra effort and place extra attention on ensuring that the examinee is comfortable. Make sure that they're comfortable in their chair. Make sure that they have a comfortable chair. Don't stick them in an uncomfortable chair for a lengthy period of time. Make sure that they are comfortable with the temperature in the room. Many times it's necessary to actually lower the temperature in the room. If the examinee is somewhat apprehensive, perhaps somewhat nervous, perhaps a little bit adrenalized, they may be a little bit hot. And so inquire to them as to the temperature in the room and ask them, how's the temperature in the room? And if they indicate that they might be a little bit more comfortable with the room a little cooler, make sure that they're accommodated in that way. It's important that they be comfortable and that they not be self-conscious. Number 3, make sure that they're comfortable. Ask them if they need to use the men's or ladies' room before we get started. Ask them if they'd like to have a beverage and have an extra beverage available. I like to carry an extra bottled water. So I have a bottled water for myself, and I bring a bottled water for the examinee as well. And it also sort of serves as an icebreaker and sort of a rapport builder if they see that both you and they are sort of simultaneously sharing a drink, so to speak, even though it's simply a bottle of bottled water. So the point of this is to make sure that they're comfortable and make sure that they're relaxed and make sure that they're not self-conscious. Okay, so once that's established, we can then complete our procedures and start working our way into the face-to-face interview with the examinee. And our final procedure in the setting of the tone of the evaluation involves the prepared statement according to Labor Code 4062.3 and California Code of Regulations 40. And I'll show you this prepared statement in just a moment. But before I do that, I want to let you know sort of the history of the adoption of this prepared statement. And you may or may not be aware, but prior to the face-to-face evaluation with the injured worker, we are required to inform the examinee of several of their rights as an injured worker during the evaluation process. Now, not many doctors actually go through this procedure, but it's actually required. So several years ago, I had the idea, since it was a required procedure, I had the idea of simply writing out word for word the text of Labor Code 4062.3 and California Code of Regulations 40, and then simply handing the form, the text of these two codes, to the examinee and having the examinee read the language and then having the examinee to sign on the bottom of the form, to sign and date on the bottom of the form, to document that indeed I had given them the opportunity to review their rights and I had answered all their questions regarding the requirements of CCR 40. Well, before I implemented this as an official procedure and as a part of my regular routine with the injured workers, I solicited an opinion from the administrative director at the time, and this goes back several years ago. But anyway, we had a different administrative director then. It was a female. And I submitted this prepared statement, and I described the procedure as I planned to implement it to her. And I asked her for her approval of this procedure. Well, she reviewed the prepared statement, and she reviewed my idea. And she wrote back and she said she thought it was a fabulous idea. However, she had one concern and one reservation, and that was that she did not believe I had the authority to have the examinee or to require that the examinee sign and date the document, because she felt that examinees might feel that the signing of the document was somehow required in order for them to proceed with the evaluation. In all actuality, it's not. It's not required that they sign or date anything. It's simply required that we advise them of their rights during the time of the evaluation. So I modified the procedure to not require the examinee to sign or date anything, but I continued with the procedure as the administrative director had approved it, and that involved simply handing a prepared statement to the examinee and having them read it word for word, or if there was an interpreter present, having the interpreter read the document word for word, or on certain occasions, I myself would read it to them word for word and make sure that indeed this procedure was completed in its entirety. And I'll go over this document with you in just a minute. And it's important that you ask the examinee if they have any questions regarding their rights after each major point contained within Labor Codes 4062.3 and CCR 40. And it's quite interesting because after doing this for hundreds and hundreds and hundreds of evaluations, I find that examinees have only a few basic questions, if at all. And we'll go over some of those here in just a minute as we review the document. Okay, and here is that document. I have it loaded up here as a Microsoft Word document. And you can see that this is wholly contained on one sheet of paper. So I have several of these in my briefcase, and I simply hand this to the injured worker or the examinee and ask them to read this. And the script on that might go something as follows. I might say, okay, Mrs. Jones, we're now about ready to begin your evaluation, but before we do that, there's one more official procedure that we need to go through. And I have a page here which describes your rights as an injured worker. And I'm going to have you read this document. And this describes all of your rights as an injured worker, so it's important that you understand each and every paragraph contained on this document. So I want you to go ahead and read this, and then when you're done, just let me know, and we will review this together, okay? And if you have any questions at any time, you just let me know, but we will review it together when you're done, okay? And they say okay, and they read it. Now, this document contains some technical language and some workers' compensation rules and regulations that they may not understand. So what's important is that you review each line item with them when they're done reading the entirety of the document. So the examinee would read the document, and many times they may stop and ask questions as they go, or they may read all the way through and have one or two questions at the end. Sometimes examinees read all the way through and say okay, meaning that, that they don't have any questions. Regardless of how the examinee responds, make sure to review the document 100% of the time with 100% of the examinees. In other words, whether or not you review the document is unrelated to their response to the document, okay? So that would go somewhat as follows. And let me just read each one of these code sections and describe to you how some of the conversation related to each one of these subsections could go in your discussion of this with the examinee. Okay, so Labor Code 4062.3E says that all communications with an agreed medical evaluator or qualified medical evaluator selected from a panel before a medical evaluation shall be in writing and shall be served on the opposing party 20 days in advance of the evaluation, period. Any subsequent communication with the medical evaluator shall be in writing and shall be served on the opposing party when sent to the medical evaluator. So I might say, for example, to the examinee, okay, Mrs. Jones, what does the first paragraph mean to you? What do you get out of that? And she might say, that if I need to contact you, I have to do it in writing. And you might say, well, that's exactly right. Now, with regards to the communications before the evaluation and the 20-day rule, Mrs. Jones, that's already happened. That's happened already in advance of us meeting today. Now, any subsequent communication, meaning anything that you might want me to know, anything that you might want to tell me, anything that you think you may have forgotten to tell me, I want to hear it. I want to hear it. However, it has to be in writing. And when you send it to me in writing, Mrs. Jones, you also have to send a copy to the claims administrator, or you have to send a copy to your attorney, and you have to send a copy to the defense attorney. In other words, it has to be in writing and it has to be served on all the other parties. That way everyone is in the loop. Do you understand this? And they will say, yes, and they'll give you a head nod. And you might further elaborate and say, so Mrs. Jones, if you leave here today and you remember that there was something that you wanted to tell me, I can't take your phone call. Don't call me. I want to hear it, but I can't take your phone call. You would have to submit it to me in writing. Do you understand? And you get a head nod from them and you move on. And doctors, this procedure is so powerful. So powerful. The next one says that communications with an agreed medical evaluator shall be in writing and shall be served on the opposing party when sent to the agreed medical evaluator. Oral or written communications with physician staff, or as applicable, with the agreed medical evaluator relative to non-substantial matters, such as the scheduling of appointments, missed appointments, the furnishing of records and reports, and the availability of the report, do not constitute ex parte communication in violation of this section unless the appeals board has made a specific finding of an impermissible ex parte communication. So this one would apply to the AME, but not to the QME. So it's important that you elaborate on this if indeed you are an AME on the case. Section G says ex parte communication with an agreed medical evaluator or a qualified medical evaluator selected from a panel is prohibited. If a party communicates with the agreed medical evaluator or the qualified medical evaluator in violation of this section, the aggrieved party may elect to terminate the medical evaluation and seek a new evaluation from another qualified medical evaluator, or to proceed with the initial evaluation. And I might ask the examinee, so Mrs. Jones, what does that mean to you? What does that mean to you? And they might say, well, if they find out that I communicated with you but didn't notify them in writing, then they might dismiss your report. And you would simply say, well, that's correct. That's correct. In other words, Mrs. Jones, can you tell that the law is very clear that communication and lines of communication are required to flow very precisely and very specifically, and that is, it has to be in writing with copies to all parties, and by now they're getting the point, and they give you a head nod. Section H says that the party making the communication prohibited by this section shall be subject, let me say that again, shall be subject to being charged with contempt before the appeals board and shall be liable for the costs incurred by the aggrieved party as a result of the prohibited communication, including the cost of the medical evaluation, additional discovery costs, and attorney's fees for related discovery. So, Mrs. Jones, what does that mean to you? She says, well, it says that I could be liable for any costs. And you might say, yes, you can see that they're very serious about this, so it's important that you completely understand this section, and you get a head nod from them. Finally, subdivisions E and G shall not apply to oral or written communications by the employee, or if the employee is deceased, by the employee's dependent in the course of the examination or at the request of the evaluator in connection with the examination. What does that mean to you, Mrs. Jones? What that means is, during our meeting today, Mrs. Jones, we have unrestricted communication, and I'm going to ask you 100 different questions all about your condition, and you're going to tell me the whole story. But after the evaluation is over, I can call you if I have additional questions, or I can call you if I need you to agree to x-ray studies, or I can call you if I'm referring you to a specialist, and I can call you if it's in connection with this examination. However, you cannot call me. Do you understand? And they will give you a head nod, and that fully handles this section. They then go on to the second half of the page, which is California Code of Regulations 40. And let's just go over these regulations together. Section A says, an evaluator selected from a QME panel shall advise an injured worker prior to or at the time of the actual evaluation of the following. So in other words, this is required. CCR 40 says that we shall advise an injured worker prior to or at the time of the evaluation of the following. It's required. And I found not many doctors comply with this requirement. But this procedure is so powerful, and I recommend that you do it exactly as I'm describing it to you, because I've done it this way myself hundreds and hundreds and hundreds of times. And before I even did it the very first time, I got an agreement from the administrative director that it was a valuable procedure to do. And she approved it in its entirety, with the one exception that I explained to you earlier. Okay, so let's just read and review some of the things that we are required to advise the injured worker. Okay, and I like to do this at the time of the actual evaluation, because that gives you and me and us the opportunity to discuss these things with the injured worker. And doctors, I say that this is such a powerful procedure because it helps to establish the tone of the evaluation, and you'll see more what I mean about that as we go through these regulations. But the philosophy of this whole section that we've been talking about in the non-physical examination face-to-face evaluation procedures is all about, number one, establishing rapport with the examinee, number two, getting them comfortable and getting them relaxed and confident in you, and then number three, establishing a tone of official proceedings and doctor control, and establishing rapport with them. And this procedure is so powerful. So let's review these regulations. Section A1 says that he or she, meaning the examinee, he or she, is entitled to ask the QME, and the QME shall promptly answer questions about any matter concerning the evaluation process in which the QME and the injured worker are involved. And you'll notice here on my template, I've included the clarification words, or the contextual clues, of me and you, so that it's clear to the examinee who's who. So you might say to the examinee, so Mrs. Jones, what does section code number 1 mean to you? And she would say that I can ask you questions at any time, and you're supposed to answer them. And you would say, that's correct. So if you have any question at any time, just let me know. and I'll answer it to the best of my ability. I might not know the answer, but if I don't, I'll tell you, and I'll answer your questions to the very best of my ability. Okay, Mrs. Jones, it's important that you have your questions answered. So if you have any questions, you let me know, and you get a head nod from them. Okay, Section 2 says that subject to Section 41G, which is another code of regulation, the injured worker may discontinue the evaluation based on good cause. Good cause includes A, discriminatory conduct by the evaluator towards the worker based on race, sex, national origin, religion, or sexual preference. Good cause includes B, abusive, hostile, or rude behavior, including behavior that clearly demonstrates a bias against injured workers. And good cause includes C, instances where the evaluator requests the worker to submit to an unnecessary exam or procedure. Now, this is so powerful. Listen very carefully here, doctors. So you may say to the injured worker or the examinee, okay, Mrs. Jones, what does that section mean to you? What do you get out of that section? And the injured worker says, it says that I can discontinue the evaluation if I feel that you're rude or you're abusive or that you have an attitude about injured workers, or if I have to do an unnecessary exam. And you would say to them, exactly. Now, doctors, this is the examinee's out clause, quote unquote out clause. If they don't like you, they can exercise their out clause. This is their out clause. Now, our job as evaluators is to make sure that they have no reason, no reason to exercise their out clause. So you might say to them, that's right, Mrs. Jones. If at any time you don't feel comfortable here, if you feel that I'm rude, abusive, hostile, if you feel that I'm discriminatory in any way, you don't have to put up with that. You can simply give me a high five and you can leave. You don't have to put up with any type of behavior or any type of attitude from the examiner, which is me. Do you understand that? And they'll nod their head. And then you finish up by saying, and Mrs. Jones, you won't be required to do any unnecessary examination procedures. For example, your injury involves your neck and your right shoulder. So as an example, you won't have to disrobe. In other words, it's not necessary for you to disrobe. It's not necessary for me to examine your neck and your shoulder for you to disrobe. Now, if, for example, the examination is going to involve, I don't know, I'm making this up, perhaps the lumbar spine, you might say to the injured worker, now, Mrs. Jones, because your examination involves your lower back and your lumbar spine, you may be required to unzip your pants to expose the lower back and the tailbone area. I have a towel so that you'd be completely covered. And so would you be comfortable with that? And get a head nod from them in advance as to the scope and extent of the examination procedure. Now, doctors, let's talk about this for just a moment. Some doctors have asked me, do I want to disclose to the examinee that they can discontinue the evaluation? I mean, doesn't that increase the likelihood that they would or should or could discontinue the evaluation? And my answer to that is, well, yes, if they do feel that you're rude, if they do feel that you're abusive, if they feel that you're hostile, they now know that they don't have to put up with that and they can leave. But your job is to be caring and kind and supportive of them. And your job is to have an attitude of liberal construction. And from here on out, you demonstrate to the examinee that you know that they can leave. You know that they can leave, and they know that they can leave. And your job is to make sure that they stay with you and that they complete the evaluation with you in a manner that they're completely comfortable with. Okay? This is so powerful, and I've never had a single examinee after doing thousands, over 1,500 evaluations. I've never had a single examinee discontinue the evaluation. And part of the reason is this very procedure here. Okay, so almost done with this prepared statement. Let's go on to section B. It says that when required as a condition of probation, and the probation is either by the council, meaning the Industrial Medical Council, or his or her licensing authority, so that could be the California Acupuncture Board, that could be the California Medical Board, that could be the Board of Chiropractic Examiners, whatever the licensing authority is, not just the medical unit of the Division of Workers' Compensation, but any licensing authority. The QME shall disclose his or her probationary status. Now, I've known doctors who have been on discipline that neglect this procedure, but it's required. It's actually required. Now, why do doctors omit this procedure? They omit it because they're afraid that the examinee may discontinue the evaluation. But the code and the regulation requires that you give the examinee the option of either continuing or discontinuing the evaluation by disclosing any probationary status. Now, if you are on probationary status, the code says that the QME shall be entitled to explain any circumstance surrounding the probation. If at that time the injured worker declines to proceed with the evaluation, such termination shall be considered by the administrative director to have occurred for good cause. So in my situation, I simply tell the examinee that, Mrs. Jones, I'm not on probation by any licensing authority. And we usually both just smile and laugh about that. If you are on probation, you would explain to them something similar to this following. And I'm just making this up as a sample script. You may have a better script. But it might go something as follows. Mrs. Jones, what do you get out of section B? She'll say, oh, it's required that you tell me about any probation. And you might say, well, Mrs. Jones, I am on discipline with my licensing authority, which is the California Acupuncture Board. Now, the reason I'm on discipline with the California Acupuncture Board is because our licenses renew every year on our birthday. And last year I was, this year I was 6 weeks late with reapplying for my license and paying the fee. And for that reason, I'm on a brief probation. But that probation has nothing to do with my clinical competence. It simply has to do with my licensing application. Are you comfortable with me as your evaluator, and are you comfortable to continue with me as the evaluator under those circumstances? And the examinee may ask some questions. She may say, does your discipline have anything to do with the examination of women? And you could say no. And she could say, well, it's simply due to your licensing being delayed. And you would assure her that, yes, that's the cause. And she may say, well, okay, I'm comfortable to proceed with you. Or something like this. I'm making that up, but you're required to disclose it, and you're required to explain the circumstance, and you're required to give the examinee the option to either continue or discontinue with you. Finally, last section says, if the injured worker declines to ask any questions relating to the evaluation procedure as set forth above in 40A and does not otherwise object on the grounds of good cause to the exam proceedings under section 41A, during the exam itself, The injured worker shall have no right to object to the QME comprehensive medical legal evaluation based on a violation of this section. So you might say, well, Mrs. Jones, what does that mean to you? What do you get out of that? And this one is sometimes confusing to the examinees, but they'll read it again and they'll say that if I don't have any questions during the exam, that I can't object to the exam later. And you would say, exactly. Now, what does that mean to you, Mrs. Jones? And they'll say, I don't know. And you can help them out with some explanation as follows. You might say, okay, Mrs. Jones, so we talked about questions. If you have questions at any time, just let me know and I'll make sure that you're comfortable with your question, and I'll make sure to answer your question to my best ability, okay? And get a head nod. Okay, so Mrs. Jones, what it says is that if you go through the full examination procedure and you're comfortable with me, you're comfortable that I'm not rude, you're comfortable that I'm not abusive, you're comfortable that I'm not hostile, and you complete the evaluation with me, you can't later object to the evaluation after you get my report. Why is that important, Mrs. Jones? Why do they put this regulation in here? And they'll say, well, I don't know. And you say, well, Mrs. Jones, imagine this. You're an injured worker, and you have an attorney, and there's an insurance company involved with this case, and the insurance company has an attorney, and that's 4 people. And I usually hold up my 4 fingers and I wiggle 4 fingers and I show her that that involves 4 parties. And maybe I'll count them off on my hand. That's you, that's your attorney, that's the insurance company, and the insurance company's attorney. That's 4 parties, Mrs. Jones. Now, it's possible that when I write my report, Mrs. Jones, one or more of those parties is not going to be completely happy with my conclusions. Even though I'm doing my very best job and putting down my honest opinions and conclusions, it's possible that one or more of those parties is not going to be happy with my report. Can you see that? And they'll say, well, yeah, I can imagine that. I see you have a tough job to do, and I could imagine that, yeah, it's hard to please all the people all the time. And you'll continue and you'll say, well, that's correct, Mrs. Jones. And sometimes it's the examinee, it's the injured worker like you that sometimes is not happy with my opinions or conclusions. I don't know how I'm going to conclude in your case. I can assure you that I'm going to give my honest opinion on your condition and my honest opinions on your case. But it's possible that you could disagree with some of my opinions and conclusions. But you can't then object to my report. If you have a problem during the evaluation itself, if you have a problem with me, if there's any time that you're not comfortable, declare it during the evaluation, because you have no opportunity to declare it later on. Do you understand? And you get a head nod from them, and then once this is complete, you ask them, okay, now before we begin, do you have any questions? And they will say, and I've done this hundreds and hundreds and hundreds of times, they will say, no, I think that just about does it. Let's begin. And you may now begin the evaluation process.